Hello, I'm Ken Parish from Parish McCulloch, Barristers and Solicitors. I want to talk to you today about the question of costs and quality of service for legal services provided by private law firms. Now, I've been running law firms, both large and small, for the better part of 30 years, in fact almost exactly 30 years. And I've worked out over that time what's the best and most cost-effective way of delivering legal services to clients, especially in an affordable way. Because you see, well, it won't come as a surprise to you to know that legal services are very, very, very expensive. In many respects, that's unavoidable because it is very much a labour-intensive industry. It's one where you have to have offices and sophisticated equipment and to some extent paralegals and secretaries and so forth. And you have to go through a lot of training to get the lawyer's practicing certificate. You have to have detailed precedents and research resources and so on to be able to practice in a proper and effective manner and deliver the sorts of excellent results that your clients are entitled to expect. Now, what that means, certainly with all of the large law firms and most of, if not all of the medium-sized law firms and quite a few even of the smaller ones, is that the hourly rates that lawyers charge are very high. Typically with a large to medium law firm, you will find that the lawyer will be charging out their time at the rate of perhaps $500 an hour. Even a very junior lawyer, straight out of law school with still lots to learn, is typically charged out at $400 per hour. Now that's an awful lot of money. And you do have to question whether it needs to be like that. I guess if you are a big company, a big ASX 500 company like BHP Billiton or Coles or Bunnings or somebody like that, those sorts of charge rates are acceptable. And you're at the end of the day, I guess even for small people, if you can somehow fund it, or if you've got a law firm that's doing it on a no-win, no-fee basis or something like that, then maybe you can come at those sorts of fees. But they're still pretty high. And I've set up this law firm that I'm running now with some colleagues in order to be able to deliver excellent legal services to clients, to small clients, ordinary people, families, retired people, small businesses and so on, at a more affordable cost. Now, to give you an idea of how this comes into its own, perhaps the best way of doing it is to look at how costs are awarded and charged out in civil and commercial litigation matters. Now, it's often said that with litigation, with court matters, costs follow the event. Now, what does that mean? Well, pretty obviously it means that the loser pays the winner's costs. So if you're a plaintiff who commenced proceedings in the Supreme Court seeking damages of say $200,000 for a breach of contract matter, and you win that case, then the losing defendant will be ordered to pay your costs. Conversely, if you lose the matter, then you'll be ordered to pay the defendant's costs, the winning defendant's costs. But what does costs mean? Does that mean that the losing party pays all of your legal costs, so you've got no out-of-pocket costs to your own lawyer? Well, sadly, the answer is no, because you will have signed a costs agreement with your lawyer, agreeing to pay, if it's a large firm, $500 for every hour that the senior solicitor spends, and $400 per hour for every hour that the junior solicitor spends, all computed in 6-minute intervals. So even if they do part of 6 minutes, they still get to charge the 6 minutes worth, which is $50 for the senior solicitor for every every little phone call they make, and so on. So it certainly adds up. Now the trouble is, you're not going to get anywhere near all of that back under the costs order that's been made in your favour by the court, because the Supreme Court, and this applies to courts at all levels interstate as well, the Supreme Court of the Northern Territory has a cost scale where at the moment the hourly charge out rate on the face of it is $260 an hour, $26 for every 6-minute unit. Now that's not the end of the story though, because there's also under the Northern Territory Supreme Court costs rules, this doesn't apply in all other courts and jurisdictions, but certainly the way that our costs rules work, there's also a care and conduct allowance that's added on to the top of that hourly rate to the total of the tab for the practitioner, and it's a discretionary percentage, but the way it generally works is that care and conduct allowance for a junior solicitor handling a matter will be 15% on top of the fees computed on that hourly rate, and for a senior practitioner, a more senior practitioner, it'll be 40% for on top of that hourly rate total. So if you do some very quick mathematics, you'll discover that the effective rate of recovery that you'll get under a costs order, if you're the successful litigant, is that you'll get back around about $300 for every hour that a junior solicitor spends on your matter, and you'll get back around about $360 per hour for every hour that the senior solicitor spends on the matter. Now again, with a little bit of very quick higher mathematics, you'll have worked out that means that on the costs order, for every hour that a junior solicitor spends on it, you're dropping $100 that you've got to pay to your lawyer, but you're not going to get back from the other side. And similarly, for every hour that the senior solicitor spends on it, you're dropping $140 per hour that you'll have to pay to your lawyer, but you won't get back from the other side. Now, what that typically means, with some other aspects of the rules, is that typically you can expect to get back under a costs order, when you win the case, only around 60% of the actual costs that you have to pay to your lawyer. And that can be quite a big shortfall. If, for example, I think I said before, if on that $200,000 damages award, your lawyer has charged you costs of $100,000, which is not untypical for a reasonable sized Supreme Court contested matter that goes right through to a trial, $100,000, you're only going to get back 60% of that, or $60,000. So instead of having $200,000 in the hand, you're only going to have $160,000 in the hand. And of course it can get worse than that, because it's not at all unusual for costs in a medium-sized Supreme Court matter, one where there's $200,000 or $300,000 in dispute, for the costs themselves to be around $200,000 or $300,000. Now, if that's the case, and you're only getting back 60% of what you have to pay to your lawyers, it can easily happen that the actual damages award that you will receive in your hand will be only around about half. That half of your damages award will end up going to your lawyers. Now that's pretty significant. And I might say it gets even worse in lower courts, in the local court, or in Victoria, the county court, where the cost scale is not as generous, but your lawyers are still charging you at that, usually at that premium sort of rate, the $400 to $500 an hour rate. So you are likely to lose even more of a percentage of your damages award in lower court civil litigation. Well, At Parish McCulloch, we've addressed that problem. What we've done is set up our legal practice structure to be as efficient, as cost effective as possible. We've got very experienced lawyers, myself with 30 years experience, and our senior consultants, particularly Tony Crane and Gordon Parish, with similar levels of experience. Now, the way we do that is partly by making maximum use of those consultants, and partly also by making maximum use of state-of-the-art legal technology, internet technology and other technologies. So we've invested in the latest automatic document creation software. We use speech recognition software. That's one of the reasons why I've got this funny looking headset microphone on, so that we can generate complex legal documents quickly without needing squadrons of secretaries and paralegals who add to your overheads. We've also got the latest cloud-based practice management system, so that with electronic files and so on, so that our consultants can log on and access the file and work on the file from wherever they are in Australia, or even overseas for that matter. We've also invested in a huge range of automated legal forms and precedents, similar sorts of numbers and complexity to what a very large firm has. And we've also invested in a huge range of online legal research resources, so that what you end up having with Parish McCulloch is the resources and the quality of service of a large firm, but with the costs and personal service of a very small firm. So at the moment, my top charge out rate for work that I do is $360 an hour. I'll sometimes negotiate lower rates than that, but my typical rate is $360 an hour. As you'll note from what I said before, that should mean that in Supreme Court litigation you should get back close to 100% of the fees that we charge you if you win your case. And in fact, I'll guarantee you that we will recover at least 80%. And if we don't recover 80%, we'll carry the shortfall. We'll cut our fees to meet that. So we also do fixed fee arrangements for commercial work, so you'll know exactly what you're up for in advance. So the bottom line is we are able to deliver legal services at something like 3/4 of the price that big to medium and even many small firms charge. So we only charge 75% of the sorts of rates that those firms charge. Now, it's still significant money, and for ordinary people and small businesses, it means that deciding to run a legal matter is a significant decision. But nevertheless, I'd suggest that for many disputes, it's really the only way to go. There's not much point in muddling through and losing a case when in fact you could have won it if you'd had good legal representation. Similarly with commercial documents, agreements and so on in business situations and even in personal situations. I've, in my 30 years of practice, seen many cases where people have muddled through and written their own legal documents, and then when things fall apart, it's complete disaster. You really do need to be an expert to draft a good legal document that will properly protect your interests. And again, we can do that on a fixed fee basis where we'll give you a quote up front, you'll know exactly what you're up for, and you can decide on it. So anyway, that's the services provided by Parish McCulloch. I hope you will give us a try next time you need some legal work done.